Hello and welcome to the ABA section of Environment, Energy, and Resources podcast. My name is Cynthia Harris with the Native American Resources Committee. Today our guest is Taiawagi Helton, a professor of law at the University of Oklahoma College of Law, to talk about a recent case making its way through the tribal courts of the Pawnee Nation. The Pawnee Nation has sued to seek damages for an earthquake they said was caused from man-made activity related to hydraulic fracturing, aka fracking. Professor Helton began his legal career as a clerk for the Honorable Robert H. Henry, U.S. Court of Appeals for the 10th Circuit. He served as a special justice for the Cheyenne and Arapaho Tribe Supreme Court and as a member of the Board of Directors of Oklahoma Indian Legal Services. His research emphasizes environmental and natural resources issues relating to Native Americans, as well as nation building in Indian country. Professor Helton, thanks so much for joining us today.
I'm pleased to be here. Thank you.
In a nutshell, what exactly is the tribe alleging?
Well, the tribe is alleging that the injection of wastewater from a variety of oil and gas operations, not just fracking, but it's expanded since fracking became popular. The injection of wastewater back into the ground has induced seismicity. That is, it has caused earthquakes because the injection of wastewater deep underground changes the subsurface dynamics of pressure and friction, and that causes earthquakes. In Oklahoma, we have seen a radical increase in the number of earthquakes in recent years. I think if you look at the years from 2010 to 12, we averaged about 48 magnitude 3 or greater earthquakes, and I say that because that's about magnitude 3 is about what's required for people to feel it. The average has been about 702 of those earthquakes per year in 2014 through 16. So we've seen a radical increase in the number of earthquakes, and the tribe claims that those man-made earthquakes has caused damage to their real property and to their historic buildings. And so they're claiming that wastewater injection is an ultra-hazardous activity, and therefore there's absolute and strict liability, but also that there is negligence, nuisance, and trespass that has led to damage to the tribe's property.
So from one viewpoint, it seems very much like a typical, almost typical tort case. But here, what seems to be unique is the tribe is suing in tribal court. Now, what exactly is the advantage? Why would the Pawnee Nation strategically want to sue in tribal court rather than state court?
Well, candidly, the damage has taken place in the tribal territory, and therefore the tribal court is, I think, the appropriate jurisdiction and venue for a lawsuit like this. You know, we're taught in high school civics that we have a system of bilateral federalism, that we have state sovereigns and federal sovereigns. That is not true. We actually have a system of trilateral federalism. Tribes are sovereigns. The Supreme Court has described them as pre-constitutional sovereigns whose sovereignty is not delegated, but it is inherent in their status as peoples, and they have the power to make their own laws and be governed by them. And so they have court systems, and they have sovereignty and jurisdiction that allows them to adjudicate cases arising from damage in their territory.
And what are aspects of the Pawnee Nation's tribal court system specifically that might differ from what we would typically expect in a state court action?
Good question. So, you know, if you've seen recent discussions about budget problems in Oklahoma, Oklahoma is clearly very loyal to the oil and gas industry, and we charge lower taxes than any other state does for oil and gas operations, and that includes very industry-friendly states like Texas and North Dakota. And I think Oklahoma courts would be reluctant, perhaps, to you know, entertain lawsuits against the oil and gas industry, since so much of the state's economy depends on the oil and gas industry. For the tribe, though, their direct loyalty is to the people within their territory and to their tribal members. And I think the Pawnee Nation has a sense that is accurate, that their tribal court would be more likely to give a neutral hearing to this kind of claim, than a court system that is generally more sympathetic to the industry than to those on whom industry costs have been externalized.
I'd be a bit curious if there are any sort of procedural differences or any unique aspects to the tribal law in the Pawnee Nation that would be interesting to follow.
Sure. So I think that Pawnee Nation tort law is not markedly different from the tort law in the several states. But in terms of procedure, tribal jurisdiction over this matter is a question of federal law. But there is a requirement of exhaustion. So there are a couple of Supreme Court cases that are now famous. Iowa Mutual Insurance Company versus LaPlante and National Farmers Union Insurance Company versus Crow Tribe, in which the U.S. Supreme Court said that as a matter of comity and to provide for the development of tribal court systems, that parties, before they could come to federal court, had to exhaust remedies in tribal court. So we will have a trial in tribal court and an appeal through the tribal court system, and then a federal court is allowed to review the tribal court proceedings. But on a very limited basis. The federal court has federal question jurisdiction, but the only federal question that they can answer is, did the tribe properly determine, as a matter of U.S. law, the scope of its own jurisdiction over the tortfeasors here? And if the court says no, that the tribe did not have jurisdiction, then that will stay the tribal court's order during the federal appellate process. But if the federal court determines that the tribe accurately determined that it did have jurisdiction over these companies, then the federal court is not supposed to look any further into the substance of the judgment. So if they say, yes, you had jurisdiction, they should not then go on to say, and we approve or disapprove of the jury award, for example. They're supposed to only answer the federal question, and as a matter of U.S. law, the federal question is, did the tribe have jurisdiction over these non-member corporations?
And of course, we have to talk a bit more about tribal jurisdiction, especially regarding Montana and now with the Dollar General and its current status. What do you see as implications for tribal civil jurisdiction with this case?
I think that the tribe very likely has jurisdiction in this case. We started out at the establishment of the United States with tribes being entirely self-governing, but over a period of 2 centuries or so, tribes have, through a series of court cases and congressional statutes, been incorporated into the United States, and but they retain the right of self-governance. However, in the 1980s, in 1981, the Supreme Court issued a decision in Montana that said there is a general presumption that tribes lack jurisdiction over non-members or non-Indians on non-member fee lands within the reservation, unless or with 2 exceptions. So in other words, the tribe has jurisdiction on all tribal lands over everybody in the Montana ruling, and that they have jurisdiction over tribal members no matter what the status of the land. And although these rules have changed a little bit, it's still generally true that the tribe is said to have limited jurisdiction over non-members on non-member fee land. But the court said there are 2 exceptions. That tribes do have jurisdiction over non-members who enter into consensual relationships with the tribes, including contracts, leases, or other arrangements, or they have jurisdiction over non-member activities if those activities have a direct effect on the political integrity, economic security, or health and welfare of the tribe or its members. And it seems clear to me that the inducement of earthquakes at the 3 to 5.6 or 5.8 magnitude level certainly has a direct effect on economic security, because it destroys the property, including the economic the foundation for the tribal economy, and it certainly affects the health and safety of tribal members, because we all know that people die in earthquakes throughout the United States and the world every year.
Absolutely. So it seems a pretty clear application of exception number 2, is it?
I think that's right. I think that the second Montana exception would clearly apply in this case, and that the companies, would certainly be liable. The other thing to keep in mind is that even if we're not within the original boundaries of the reservation, if this is off-reservation conduct that has consequences on the reservation, then there's a good argument that the law that governs is the law where the injury occurred. And the jurisdiction is the place where the injury occurred. And one thing that we know about these injection-induced earthquakes is that they can have an earthquake triggering effect 10 or 15 miles away from the location of the well, although we are getting better and better at identifying the specific well that winds up being the source of the earthquake. And that's something that science is picking up with rather quickly. So I think even if this is off-reservation conduct, the damage is directly caused on the reservation, and I think that would justify the application of tribal jurisdiction.
I want to bring it back to something you discussed earlier regarding the relationship between how the state perceives the energy industry as sort of a benefit, at least over the past few years, versus how tribes might view it. It seems there might be a bit of conflict because some tribes welcome energy companies and the economic benefits they bring. Some tribes, and I believe the Pawnee are one of them, have actually banned hydraulic fracturing. Would you be able to talk a bit more about how that is viewed by different tribes in Oklahoma specifically?
Sure, you're quite right. There are many tribes that, like the state of Oklahoma, derive substantial revenue from oil and gas activities. There are other tribes that do not, but bear environmental consequences from those activities. And so I'm not sure how the tribes in Oklahoma would divide specifically, but there's no doubt a range of opinions about the extent to which these activities should be regulated. However, even for tribes that derive substantial revenue, they still seek a balanced approach to regulation so that you have the industry being able to produce revenue, but forcing the industry to internalize the costs of its activities so that those costs get considered by the people who make the decisions. And so I think tribes, even those that are quite friendly with the oil and gas industry, are not wholly disconnected from the people that are burdened by oil and gas development in Oklahoma or on tribal lands.
Now, for environmental lawyers and I suppose anyone interested in federal Indian law and tribal sovereignty in general, what do you think we should be focusing on observing this case as it unfolds?
The things that I find most interesting about the petition, first, I think the application of Montana is an interesting question, although it may not be the governing question, but I think this is a really important example of the direct effects test. But I also think that the tribe alleges significant contacts which would suggest personal jurisdiction over these companies as well, in a way that's outside the ordinary Montana consensual relations or direct effects analysis. And so if you're interested in Indian law, I think that significant contacts analysis that we'll all remember from our civil procedure courses, I think that's a really interesting question. And then I think the causation question is interesting, and that would be interesting regardless of whether we were in tribal or state or federal court. With climate change, we note that, as more energy is pumped into the climate system, we should expect more intense storms. And so it's no surprise then that a storm the magnitude of which we would have only seen once every 100 years, we might now see every 5 or 10 or 20 years. But there's this problem of saying this particular storm was caused by climate change, because it could be the one-in-a-century storm of that magnitude. So we know they'll be happening more frequently, and when we see them, it's easy to make that attribution, but we have to be careful to note that it's hard to guarantee that this particular storm is one caused by climate change. Having said that, that there's this parallel with, was this particular earthquake caused by that particular well, the causal relationships are less complicated and they are clearer. And even I've got a couple of friends that are geologists in the industry, and I remember a few years ago we were having a conversation about whether drinking water was affected by wastewater injection, and they were both, really adamant that was an overblown concern. But in that same conversation, they both volunteered that when it comes to earthquakes, that's clearly our problem. It was really funny the way they just said, oh yeah, earthquakes, yeah, we're definitely causing those. There's no doubt that our injection is inducing seismicity. And we are getting better and better at determining what well activity is triggering an event, because we know about the fault lines and we know much more about the volumes and pressures being used at individual well sites when seismic events occur. And so although there's a parallel about the causation question, I think it's more easily answered in the induced earthquake scenario than in the climate change scenario. But I think it's a fascinating question from an environmental perspective.
And you bring up climate change, which is a good point. We see a number of communities in Alaska, the Pacific Northwest, and of course in Louisiana that have been affected by that, sort of on the forefront. So looking at that sort of larger, what do you see as additional environmental issues that are sort of emerging that are having a particular impact on tribes?
Well, tribes, there are nearly 600 federally recognized tribes and bands in the United States, and they occupy everywhere from northern Alaska to southern Florida. So it's hard to make a generalized statement about the effects on tribes. But what is clear is that tribal communities, like indigenous communities in other places and like poor communities in other places, are the least responsible for the causes of climate change, but they are also in the worst position for the most part to adapt to and respond to the problems caused by climate change. In other words, they bear very little responsibility for the cause, but they bear an inordinate burden from climate change. And so we are seeing the greatest effect on Alaska Native villages right now, because there is a inordinate impact of climate change in the Arctic regions. But we are seeing expanding desertification in the American Southwest, making water all the more scarce. And as you know, the Colorado River is already well over appropriated. In Oklahoma, we expect to see roughly the same average annual rainfall, but we expect that it will be coming in torrential storms separated by long droughts. And tribal communities will definitely be affected by that. And for coastal communities like those in Florida and in Louisiana, we are literally watching the ocean eat away at American and tribal territory. And we will be watching not just global environmental refugees, but we're going to be seeing increasing domestic displacement as well. And, if you think about Hurricane Katrina, a great amount of the Louisiana population left Louisiana and entered states like Arkansas and Oklahoma and Texas, and they didn't go home. And so we should expect that there will be migrations moving away from desert areas and away from the coastlines toward more central states, and that's going to affect tribal communities and Midwestern states in ways that I don't think we're preparing for right now.
That's an excellent point. We have seen some aid for tribes like the Biloxi, Chitimacha, Choctaw, and Louisiana to relocate their community, and we're seeing efforts in different parts of Alaska, as you mentioned. And to close this out, because this is such a important issue, what do you see as sort of the legal implications or potential strategies these communities are either taking or should possibly even consider taking?
Well, I think the place to start is with the trust doctrine. When the United States claimed supremacy over indigenous people in North America, it described them, famously Chief Justice Marshall, in a series of 3 cases, from 1823 to 1832, known as the Marshall Trilogy, described tribes as domestic dependent nations, and that had three components to it. That the tribes have reserved rights, that they have inherent sovereignty, but that sovereignty has been diminished by discovery and conquest, that Congress has plenary power over affairs with Indians, and that power is exclusive of the states, and it is anchored in Congress within the federal government. But third, the trust doctrine. And the trust doctrine is a power-conferring doctrine, meaning that it gives Congress powers over Indian affairs beyond those explicitly mentioned in the Constitution, but it also creates a trust duty. And Marshall famously said that the relationship between tribal governments and the federal government, it looks like that of a ward and a guardian. And later courts have clearly said that the federal government has a trust responsibility to tribal communities. And the United States has acknowledged that repeatedly, including in committing resources to relocating certain Alaska Native communities and certain communities along the Gulf Coast. So I think the first place to look would be to the federal government fulfilling its duty to preserve the lives and resources of tribal communities that, who once occupied 100% of the United States and now only occupy about 2% of it. And then beyond that, I think you've got substantive legal questions outside of the field of Indian law that would include, torts and nuisance and damage to territorial integrity that would provide separate causes of action for these individual tribes. Having said all of that in the legal context, I think that the political solution is just as important, that tribes as sovereigns should be negotiating with the United States, and I hope that the United States will keep its word and will negotiate in good faith to help preserve tribal resources. So I think we need a multifaceted approach to make sure that tribal communities don't get ignored when similarly situated communities start to receive benefits from places like FEMA and other federal programs to protect them against the increasing consequences of climate change.
That's an excellent point, because it seems like we may even be entering a new era of sort of civic engagement by different tribal communities.
I'm sorry, say that again, please.
And, well, given certain recent events, whether it's Dakota Access or Pacific Northwest, it does seem that we're entering a new era of civic engagement, especially among younger members of different tribal communities. So this may be the time.
That's a good observation. I think that's right. For a very long time, tribes being treated as wards were often forced to be passive landlords as their resources were being extracted. But in the 30s, a very little bit, but then particularly since the 1980s, Congress and the executive branches have been increasingly engaged with tribes so that tribes have more control over their own resource decisions, although it's still more limited than it ought to be. And there are a number of statutes that require consultation with tribes for certain development activities or activities that will have environmental consequences. So there's a consultation requirement under the National Environmental Policy Act and also under Section 106 of the National Historic Preservation Act. But candidly, we've not seen the current administration engage with meaningful consultation, and the Dakota Access Pipeline was a good example of that. The tribe complained consistently throughout multiple presidential administrations that it was being notified of what was taking place on or near its lands and being notified of the potential consequences to its drinking water, but it wasn't being consulted. It wasn't being given a voice at the table, and it wasn't being meaningfully engaged. It was just being told what was happening. And I think the federal government has a long way to go in respecting tribal communities as the law requires and respecting tribal communities as their rights of citizenship require and as their human rights require.
And unfortunately, on that very important salient note, that's all the time we have today. And I'd like to thank you once more for taking the time to be with us today, Professor Helton.
I'm delighted to chat.
If you've enjoyed this podcast, Please remember to subscribe and to rate and review us on iTunes. Help spread the word about us by sharing us with your friends. We do appreciate your support. For the ABA section of Environment, Energy, and Resources, this is Cynthia Harris with the Native American Resources Committee.
This program is produced by the ABA section of Environment, Energy, and Resources. If you enjoyed this program, please rate and review us on iTunes, and help us spread the word by recommending us to your colleagues. To learn more about our section and to join us, please visit our website at www.americanbar.org/environ.